Honorable Ekow Vincent asefo ye Tafo mrase bedwani me kwa manso ne yankoti adwuma yimfiri wotew Honorable dia che bia so ni ma che
Judicial Provincial
pacho na mu ni abrabo mboko de
I'm not a Roma. The Chema, that was Jim reading Procedural. Maybe I said that the scene and the remote children for Yankupon. Say, Wama at the patching, or my own thing. Now, I'm okay, so good to meet him.
And then I'm yes. The radiator said the Mawon Kwanya Hoden. Now, and Mokam who boom more friends and Tafo say or Momrena and Komo. And Komoni na yet be say. Minority woman as if you must say, Kwanya court to demo amunia. Akwatia MP fasono. Money in your home. But what I remark, court nana montuno, a mudia way. And money in you and answer Nina.
Well, open your my main shall be on me for the check a step from a Ghana for Ghana. Karimami Heavy. I'm a mono that is hinged on the supremacy of the Constitution. You're not porno. And no, and the team, I mean, says, Karimami Heavy. Now, the supremacy of the Constitution is also no. It is also hinged on the rule of law. Rule of law just a brass in the DVDR. Now, a brand also at every point in time, when you are applying the same, idea a pepper. I was saying, my who said, Ampa, see who are there, pepper. And identity. In the absence of a seeming justice for the poor, for the rich, it becomes very difficult for public trust or the justice system. Since 1992, I think that overall, Ghana has shown that we are a beacon of democracy, a beacon of rule of law, and we are a beacon of constitutionalism. In the one more day, the two media more say Omona, Omotra, say
101.7.
Hello, Nabo. Honorable Ekow Vincent asefua. Honorable Ekow Vincent asefua ye Tafo mrase bedwani. He belongs to the minority in parliament. Adam kuma wamra sebeje fi oka ho. Enkuma ye ni boyi eye sanano mote ya ye nokre bukwada no na Koforudia High Court. Na epempen so kra ba premtobre. Na womde amanebo Afri Court ba ye se. The Honorable Ernest Yaokumi a woye Akwatia MP. Webu court ne mutia. Wamfe ni die ni obuo. Ma court webu court asede so enti court bro for contempt wom de bia to ne tiri so ebiewu saa obekọ wunko abansa kan bench warrant no wom de bia to ne tiri se eno no se usia no bebia che traffic mu kra wotumi emwane de ne bra de ne ba court bebia obehye ne bia se che oba kra na obehye bia ono aboto a watia na so ntem sankwan fiaw wutumi mu ane se force bill e de ne breakcourt na no na ne nuanom mra se bejafo a wo mo mra se bejafie minority friends em telephone hye mu nra e kire mu se sa decision no court Koforudia High Court e take ye no wo mani hye danyo o mani hye danyo na se tia wo mani nyo ho na Honorable Ekow Vincent asefo na eja wo boye nchiremu no na ye behwe amada tia kode ye behwe na sanso enya na ne atoa enkommo no so na ye bisa se wa mada roma de akoto ye yi na wo mani nyi ho a se ode contempt etuno so and then once again warrant na wo mani nyi ho anka anamono nanka nyesei anamono nanka enyesei. Then again, Deputy Minority Whip Jerry Ahmed Saib address press conference no so honorable ya no wo nkomobo tiasra wa bia homanu tum na eno address press idie ye mo nkomo delegate the crowd and so agbamane bi okra say honorable what and so akasa say resist judicial overreach ti anu say ye pentremu kakra wa eno nto so hunti the honorable wejagba we mrase bedwani our deputy minority whip Jerry Ahmed Saib okay if madiachi bia eno won komoba no pay wadaroma awmani nam na yentumi monkomo se de se na efata when is empinu na anope yesin konwa aye bo ho komo then back to dia na me kan about mampeni dada na nado dan kwakufu adokwa kan ye wo Nigeria no abuso yes indeed wo hwe titro sajefo Dr. Kwame Nkrumah fapem a ode to wo pa no a ye beka no kra nanka amambo ni yes sustainable se de obi be ye a wawiye ye won hye ye da wo se we no man no fa so yenya I believe say enka Ghana in particular and Africa as a whole yes indeed enka ye hia se be kwa amanone ni akobo bosia wo ho na no kra ne yakobo bosia no onmo na be kire se de ye ntina ya ye mamu eduane a ye ndi ene de ayenye baby san wo pa wo de nya botre pa na wo de junior free school ban na wo chinetina wo se mo weekend the assignment o de ma no se onye research mfa minerals e wo Africa minerals nya de se wo party asene wedding reception asino meka agudi a wasase mu Africa ha ye wo na wo wi a onko Europe any abrochira man so continent aka no onko bobon hwese ne wo Africa ne bi wo wa so wo se befem de be pa nanti ewo sebi abrochira wa ebi ni ha tin tutuani je se ye be no mo ye ya sikei se bibia ye print no no one year print oban bia dia na say ye wo baby a print Ghana cedis no ene ye wo baby a print dollar ne pounds no teye den no obi de ye na ye ti asase so Europe wo mu ni Jupiter but wo musika mutumi ye du na ye de mai hata sa wo mtie de ya na ye bu no anyway ma me komre na honorable Ekow Vincent asefo na ye ne na wa ahoma so na ahomane te koye ye se nsa be kan biu na yentoa yenkom no so no gusu a o kire mu de ama ye sentia minority wo mrase bedwafie gidi se court ne me bia wo de ye Akwatia MP enya no kwan so ano na wo mani nyo ona bo yasam akwa ba fa che ahomane te koye
sometimes we can say yeah so the American your constitution about the troops and so yeah the year Juma or more to me or so much me this argument on with this argument you know perfect price the Becca and I don't know your papa so ye as Nasibija for there was a certain discussion say there's an injunction on Yeminia and Eskumiso as Nasibijani for the good people of Akwatia. For that matter, he should not be sworn in as a member of parliament. The argument was that at the time, and Eskumi had to be sworn in because he has been elected by the good people of Akwatia, elected because the Electoral Commission has gazetted him as a true owner and as a true winner of our elections na cause to Akwatia. Fast forward, and you say the other candidate on the contest here, that is the NDC candidate, up court for contempt proceedings. Now, some contempt proceedings in court, and I say, who court what? Idea also will make an application for committal proceedings, which he did. Now, the woman had said, when she been penning some that said, Obia make an application and I say a motion for committal proceedings at the High Court. The court no makwai say some motion and nipa ne dia banokra. E betumi atim and also be man the other party kwai mo no so aye dey aka na asem. Even before so ube biem ama nipa na aka na asem afan yelu na aka omo asem. And as commit through his lawyers file another motion to set aside that motion. And you see, per procedure in court. So when the motion about no be a catch or say, and also be a journey say, motion out there by the crowd. I am bringing another motion to set aside that application that you've made, because that application that you've made for want of jurisdiction. And you know, court need to be a dance and some so. Application na nipa ne dia ba ne se yen settle dia na side no se namra kwanso se namra kwanso wo judge ne this ha dia ne dia ba betu onim no that you have that docket, you should be able to listen to that application first. I want to say one more
honorable
and you say someone say okay FM. That's for that extent. I no. I said okay, ye. Isaac buy no. Isaac about go kwadu. This we on asma make can say kwadu na Isaac diaba no. Enyi so set it aside. You need to listen to me media na media ba set it aside no. Se nyansa wo mu na se nyansa ni. Se nyansa wo mu a wo be set it aside. Se nyansa ni mu na se enam mra kwan so a then you now come back to the main substantive application as a Kwaduna Isaac Bob or for the destiny.
Honorable say yet was here. Now quite say I trim you nusra and the Gua Pasuna, Yediba Kwan with Jabako. No, I was a Bacono, you didn't the and son of a Pudi Baconacano. Because Isaac, you are born to Kwadway. One, I also would be now would tear me, may know about the also would tear me. Now would tear Isaac is also. Then, son, I'll be tears for many years. May not have about the quadru. Which you have a culture for the distance, father. Adiana, a branch and the Ababa down when you know, and no more council into fortunate. And the father met me up with some say, another father also with some say. Vincent, as someone walk and say, as the Kwedu Diabano, and Memuno, there's lack or want of jurisdiction for the new council British Assembly. I mean, you, Yentia Wokasa. What say me, we are for the British Assembly? Vincent, that's my okay in the Nimba Council. So let's go back to Isaac Kweduna Wabo. The Kweduna Wabo, Maminti Isaac. That's a Bibi Omua, Mr. Megbo Kufo, and I said, Doka to Fiase. That is procedure in court. You cannot say that I have made an application to set aside a motion that has been made by the other party, and you will not even listen to that application to set aside the application that has been made by the other party for want of jurisdiction. That is number one. Number two, say what's our share? Now who they say? Court now no crime. There is a bit of a bias. And that's what suspected say. I tell you, big watch yano. And ya temper paper,
There's a minji for the destiny in this say attend with you for the destiny papa. You quickly go to the Supreme Court as an excommunicated. And the Supreme Court said, one, but who is the court to know? A boy Samuel Isaac Dibanda for the Dixon. Wabra went in the Supreme Court. Mabawa Yum. The patrol who was supervisory role was a high court. So it is our supervisory jurisdiction. Mabeda with him. The patrol. I am coming before you on the altar of two reliefs, certiorari and a prohibition. Certiorari and it says, I said, no court to know, I can go high court to know, Supreme Court and to another one. Prohibition is to say, one say, and share high court to know, from announcing, or if you like, pronouncing on similar matters at High Court and an excommunicated court the Supreme Court. So two things. The docket was in front of the High Court judge Ekow. And secondly, application where they buy here setting aside this one and when you say the judge strangely did not pay heed to a application now. And they went down and say, oh, yes, something aside, you know. And the Supreme Court application is also. The judge did not pay heed to it. Meanwhile, notice has been given to him that this is an application. And just so all these applications, you look on the Supreme Court and it's a motion to set aside and says I will was some over cano. Ya jet to move. I mean, says I send over cano. Sabinansa womb. And a possible send answer womb, and a possible send answer. So, for you to ascertain the weight of the application now, Mediabano, supported with affidavits. And what said? What area what take as application and I'm cancel and I say I'm cancel. So for the next thing, yeah, we train no and place applications we no one say Supreme Court NT application no and sana what was also be do the media. Who take that channel? And yeah, say I said Nangasan who was a person who more interest into procedure, the normal procedure in court, you won't follow it. If there was a stay of proceedings, and there's comedian and lawyer for a file application, a friend of stay of proceedings, on the 12th of February. Court, I said the return date for that application hearing was supposed to be on the 5th of March. Till you are filing a stay of proceedings application. Said the cost of High Court when you know let's stay it. I suffer dancer. At the end of Isaac, the other two for the Edmund. Court to the person of transfer. When you know, my filing an application to stay the hands of father to proceed in listening to the matter. If you say at application of media bano, say ya papa, I was a father team master movie. No who say when you are so and I say and sana Isaac accept with Isaac accept. In fact, in this application that I made to Father Dixon, that return date just a timer court and as a registrar and see a baba as a return date see a man in a castle on the 5th of March. 5th of March is the president draw. On what basis do you go ahead to commit someone for contempt and say Nipano what convicted? when you have not even given the opportunity for the person to be heard in his own application that he has made to your court? How do you deny such a person who is the opportunity to be heard, to have his day in court? Three different applications, two at your own court, one at the Supreme Court. Now the world court no crown and said you wumbuwa. Like a Supreme Court was way. I don't know about Supreme Court. Didn't na some ni na say you na so wum say you na so ni mo. Supreme Court to then it will now come back to you for you to listen. Isaac application or the other. Indeed, you would say, I tell you what, Channel. I tell you, I say, do a tree. I tell you, I say, Judge be a promotion. And the court of appeal with the chinchilla, also me go at them, me now would say, also the man, who say, may you do the amount. And so, even when there is due process, that these applications will have to be heard before you can go ahead with the committal proceedings. You know, I've gone ahead to convict the person. I don't think that this is the right way for you to get a promotion to the Court of Appeal if it's an open. And I'm just asking questions. So, because it's a Tiana, because I didn't want you to question. Me who and maybe a walk Ghana how bit me a side way. And you know, I am even surprised. Me TV penny some other. Three different applications.
Honorable Bakonzo Swa. As a me by your brother, your source, your tea, me person me be say. For the court to say, the honorable member of Akwatia, excuse me, or the ma, say. Why occupied with parliamentary duties and to own to me Emba court. And then again, woman say a willful defiance by the MP. And I maybe say a mutia wahi and womotos at the friend who say Omra or de Najuma or Yomra Sibajofi a year excuse.
In my young practice as a lawyer, me say obi the assembly or die court, and now say yes, some will be a quarter. So you know the assembly call you in. You know the assembly call you in. That's a once in a while. The Nipano entry my court. That's a lawyer will hold one the assembly anymore. With the practice that I have seen, there are a number of times that you call the plaintiff. The plaintiff is not available, but the court will go ahead to hear the matter because the lawyer is ably representing the plaintiff there. Secondly, in my young practice as a lawyer, I have not seen where almost a judge is a near basic defendant and as a respondent to be on one move entry and the Drew court into the lawyers who have crown pass and no. It's weird. It's weird. Especially when the person also show cause to the court that because of so and so and Tina meant to be my court. And the lawyers can say, oh, my client as a Kousu and then a home family. It's a plan of Kaka. Oh, Bano Crown for the time of power. My Lord, we can proceed without his presence. I don't see how judges would be listening or if you like be hearing matters in this country, especially in our high court, with the idea as a plaintiff and as a defendant, name when you are in some instances, those plaintiffs, even in their absence, and as a defendant, even in court on their behalf, let it not be said anywhere that if a plaintiff or a defendant is not able to come to court, it means that matters of this nature cannot be heard. It is not true, and that argument should not be used anywhere.
Joe. Now, honorable, Bakwa with the Buamnament, me need for Yentiasi, and say, quarter day walking in and say, Akwatia MP, at disrespecting. One, disrespecting, one much muna Bakuna Maboso, say, one much not see our Mrano. One ma, I don't know what you mean. Let me be said. I know pay me to say, no, as some no, at that. Kofodia High Court there, but honorable Nesty Okumi will go beyond Kofodia High Court at the appeal another court challenging the Ekow ewo Kofodia High Court no, meaning say Kofodia High Court no ebetumi di asem no kra, it will be dependent on the outcome of the higher court now what they appeal no Ekow. And you will be better to say until the higher court no determines asem no Kofodia High Court no entumi mfre na asem endi. And I say kakra ye wono no. And at what point and mo beto nsa friend say omra?
Well, William, at the point where the judge no Kofodia High Court in Yamutra and the Supreme Court debate application one, and there's to be the better one. And the medical culture, it is within the right of an STB to file an application at the Supreme Court. In this instance, an application for certiorari and prohibition. It is within his right to file that at the Supreme Court. Say a number of counsel, and I said a number of counsel, and I said somebody go down one. Say in so and I say in so it is a matter of the court to decide. Now, in the absence, say Ubi Tino and that's Ubi decide the matter, and you only decide after you have heard both parties. In the absence of that, you cannot. You cannot. And I repeat, you cannot. Say, I said that they are called the Supreme Court, with their family. My brother and Jama was a high court judge, and the same brother and Jama Supreme Court, and the man who checks how all of you have to operate. How can you approbate and reprobate? Even that as a way of the judgment, and with the paper judgment. That is not the principles that we use in applying our laws in this country. And so, say, I did a judge in the crowd, but show good faith, say, or no, big tea. An application to set aside the motion that was filed, or if like the competent proceedings that was filed. And Kamenya shows us a local Supreme Court, but it is because the judge, on all fours, in all indications, has shown a clear willingness to do the bidding of someone. In my anticipation, is it really the case? Just to make sure, say, oh, if I know. You're not so open because I didn't want you know. It can only give me that conclusion because a number of counsel back could see.
Until you bet me at say to say the other day Isaac the example he said assembly or high court na say parties na wo masem wo court no ba ko e the asem no ko me fa say court of appeal and Supreme Court until say Court of Appeal and Supreme Court ebedi asem na wie no High Court entumi mfra asem no.
So High Court and Supreme Court in this instance also has supervisory jurisdictions. So asem no ewo ebi a circuit court and a district court in the supervisory matter, and then you can bring it to High Court. So asem no High Court another court of appeal, in a supervisory jurisdiction, and I'll be here and order the Supreme Court. So, because the matter is with the High Court, the supervisory rule I will after the High Court, the Supreme Court. Now, at the High Court, the rule says you go attend you or honors attend or chair, and answer attend M1 also the Quatan Supreme Court. But first and foremost, you can even apply court for Ankasano. That is, if there is good faith. Say court, when you are now more, someone will be tea. They said there's could be a someone will be tea. I me now, but I want to set this aside. I am setting it aside because I believe that, in all sincerity, this cannot be the way I ever deal with this matter. So listen to my application first. And when you are able to listen to my application, then we can now go back to the main matter. If I told you, I say. Now, if you show signs, if you show signs, say I have every right within the laws to also trigger the supervisory role or supervisory jurisdiction of the Supreme Court to prohibit you. And also, as I said, say, at the end of the Supreme Court, court in the let us leave that for the court. Name cardinal among this application is for me to be heard on that application. You need to listen or hear me on the application first. If so when Timia and that's for the next and the application but no that's for the next and say what's another but mean to you. It has no basis and locus in law. It cannot be a law. It cannot. And that is not how our laws have been structured in our courts. Indeed, as someone may claim that also main crown said applications no and there's committee court down High Court and the Supreme Court mean what I say applications it has merit to. In that kind of the Macan say applications you needed to hear the applicants on those applications first. And you needed to wait for the Supreme Court to also hear the applications they are put down with Supreme Court. The Supreme Court to where we are back to the High Court. This is Supreme Court to go and say there be one application for Procedural and prohibition and the Abano. And number of questions for us and so on. Then we come back to the High Court. Say committal proceedings no and this candidate and the guy say you so move na say go or say show for contempt na fit the tears are some so I don't you say contempt proceedings na kasa it was not heard.
Okay. And talking about we speak the concerns of the constituents are one more Akwatia no and it says Sabre one more MP our freedom to walk about, to go to Parliament, or be in the Juma, will be to mean Tatano.
Well, we are a country of laws, irrespective of how we may disagree with the ruling or judgment of the court. Main country be also the entity of Brasso. Because in the same Emrano, and am I a hookine, am I in the area or memoir? And so, at every point in time, the rule of law should prevail. In my estimation, currently, there's a conviction. So be it. But the lawyers of NSCUMI has within their right to appeal on that conviction and also apply for stay of execution, which I am told has been done. Stay of execution, which I said, the judgment is not the abano. I appeal it to the Court of Appeal. So, court, the patrol conviction one. a high court, and their mammy, the client and the criminal. So our convention, the entry trends once. The appeal has been made. The stay of execution has also been made at the Court of Appeal.
All right.
In my anticipation, as soon as such an application is made, it is believed that within that short time, they should hold. It is debatable. But within the shortest possible time, I think because this matter is a matter that affects representation of hundreds of people, the Court of Appeal, the High Court, and the Supreme Court will view us an honor to make sure that we can bring some amount of finality to this issue, so that we will know whether our brother is joining us or not. But I know that our brother is joining us in Parliament.
Honorable Nopei, okay, FM, that's it.